Recorded live.
Hello, ladies and gentlemen. This is Rod. I'm back home as of Saturday, and today's Tuesday. What is today? Anyhow, it's like the 24th. I'm under house arrest. Let me tell you people what's going on here. Those out there that are telling you and making comments about what I did and how I did it, ladies and gentlemen, I want you to use your own common sense. Why would they seal my files from public viewing if they was worthless and they had no value and they meant nothing? Why would they seal every single file that I filed in? I'm on the show. Ladies and gentlemen, tonight's topic is know their language, know their rules, know their job. I've told you people from the very beginning that I do not know how to defend myself from their corruption, but I do know how to point out their corruption in the courtroom. I'm going to have Harvey repost these documents out on the big list. I want you to get into the big list and start pulling these documents. These documents expose the language. The document exposes their procedural violations. Their documents expose their foreign state violation because, ladies and gentlemen, when I did in 2008 that Corn Novus, that 4-page document, the older people on here will remember. The newer people, when that 4-page Corn Novus went out, a college professor from California called me because one of his students put this to him. That 4-page Corn Novus, which consists of a cover sheet and a proof of service, which was considered 1 page out of the 4, 2 pages were definitions, so that's 3 pages out of the 4. That 1 single page overturned every single court case in this country. It would have released 97 or 98% of the prisoners because it went back and showed the fraud of the court system, how they are foreign to you and I. And since that time, with all these other documents that we have put in, we have exposed the language, we have exposed their foreign nationality of them being foreign to us. We've literally exposed the entire corruption of the entire court system. This is why these documents are sealed. You need to go back and look at who's doing the ridiculing. What is their nobility that is making these comments? While I was in, I had to take a plea bargain. I was up to 21 years. When we sit down and we talk, the prosecutor sat here and looked at me and told me, you may not agree with what we're going to tell you. You know that you are right. I'm going to repeat that. You know, talking to me, Mr. Class, you know you are right. We can't allow you to win. You will have to plead guilty or you're going to spend a long time in prison. When they took me back to the back cell, public defender come back, and I looked at him. He said, Rod, your paperwork would overturn every court case in this country, and they can't allow you to do that. That's why my paperwork is sealed, ladies and gentlemen. This, what we have been teaching you, know their language. Learn how to read their paperwork. Learn how to come back in. Because when we used the word firearm and we laid it out under Title 26, 5845, and Title 27, 479.11, and the National Firearms Act of 1934 and the 68 Gun Control Act, and the Firearm Owner Protection Act of 1999, the definition of the word firearm is what I've been telling you people. This would overturn every gun case. When we went into the language of the word person and corporation, and we showed under the National Firearms Act that the corporation and association and partnerships all referred back to the manufacturer under the 1934 National Firearms Act, that a person is a manufacturer, that the person is a association, which meant for the manufacturer, the importer, the exporter, the dealer, the collector, and the pawnbroker. These were the definitions of corporations and associations and partnership. When we got into the word persons and we got into the IRS where it referred back to the public officials or alien enemy or alien citizen residents, this does not come back to you and I. When we got into the jurisdiction, and the only way the court could have jurisdiction was under Title 50, under Chapter 3, Alien Resident, under Section 23, where we are being charged as alien enemies resident, which refers back to an act respecting alien enemies of 1798. Ladies and gentlemen, we laid out the entire history of the corruption. We laid out the entire history of them going from a government being taken over by the federal government to becoming a corporation, to coming under UN jurisdiction as UN nationals. Ladies and gentlemen, this has been laid out in all my documents. That's why my documents are sealed. This is why when I was told, when I was arrested the first time, these people were absolutely terrified of me. Now that I've put my documentation in, they are absolutely terrified. That's why this paperwork is sealed, ladies and gentlemen. Now, I'm going to tell you right now, those of you that are on the private side, you cannot use this paperwork. You cannot. What happened with me is because I was not on the private side at that time, I was able to come in and open up and lay out all this information. I was able to expose the entire fraud of the system from procedural violations. When Kessler sat down and told me that the corpus delicti was the statute, that I violated a statute, when I proceeded to explain to her that under Title 28, 2255, writ of habeas corpus, if I could prove a constitutional violation or a statutory violation, she had to let me go. I proceeded to explain how the prosecutor violated his oath to the Bar Association under Title 36, Chapter 705, Section 70503, that he just failed to uphold the Constitution under Article 4, full faith and credit, under the 14th Amendment, equal protection under the law. He violated the federal statutes by disqualifying himself for doing so, and he violated the Smith Act of 1940. He violated Title 18, Chapter 115, 2385, sedition, insurrection, and treason. And why is this man still sitting in this courtroom? After a 35-minute lecture from me on this, she postponed the case and she walked off the bench and she never came back. That's why I got Judge Roberts. There's not a federal judge up in D.C. that would touch me after that. Roberts had to take me. Ladies and gentlemen, if you are right now not on the private side of this thing, we need to hammer them on their language, on their own rules, on their own job, of how they are violating it. This is what's got them terrified, that this is what's come out. And if it wasn't for a judge out in Oklahoma, I think her name was Judge Tatanka, she said in a group that the language has never been challenged. Nobody's ever challenged the language. And that's what we've been doing. I will repeat what I said earlier. I do not know how to defend myself against their corruption, but I do know how to point out their corruption. By knowing their language, knowing their rules, knowing their job, knowing how they're supposed to operate, terrifies these people. This is where the problem has come in with what I've done. This is why this paperwork is sealed. These people that are ridiculing me, let them. But they can't justify the sealing of my paperwork. Because I know from firsthand, because after I got out, I was told while I was in, prosecutor and a public defender sit here and told me they cannot allow me to win. I beat these people, ladies and gentlemen. But I had to pay a price here for beating them, because they can't afford to have this information out. That's why I'm on house arrest. And house arrest doesn't mean going out on the porch or out on my back step. I cross over that threshold, I'm in violation. These people are absolutely terrified. Absolutely terrified. Those of you that know about the private side, they had to dismiss my case and redo a third charge on me. They had to do a third charge. They had to re-indict me, re-arrest me, rearraign me, and run me through a third brand new trial. Because when we did what we did on the statutory side and we went to the private side, we hung them. They're hoping that I did not understand, and that was a mistake. I do understand. But ladies and gentlemen, I'm going to tell you, use this stuff at your own risk. Learn how to read the judge. Learn how to read the situation that you're involved in. Learn how to read it. What I mean by that, learn the body language. Learn the tension in the air. But I cannot express any more or any deeper. Know their language. Be able to come back and prove that the United States codes don't apply to us. This is what I pointed out with Kessler in that 35-minute dissertation that I gave her. I went back and showed her Statute at Large, Volume 43, where it stopped on March 4th, and Volume 44, where it's picked up on December 16th, and that the USC codes were never passed on December 7th because it never showed up. I showed her where it was prima facie. I went back and showed her under the Federal Register and the Industrial Recovery Act that the President and the Congress committed a committee on administrative commission that allowed them to codify the statutes for administrative uses only. So the USC codes are only administrative. This is why it only deals with public officials or alien enemies or alien residents, because any alien that come into this country has to swear an oath. Public officials have to swear an oath. Therefore, the United States statutes only apply to those who swear an oath. And we pointed this out throughout the paperwork. We pointed this out in the courtroom. Ladies and gentlemen, what we exposed and what you need to expose goes back to the Prohibition time, where 80,000 people hit the courts and went after Prohibition. They didn't know how to handle it. If 80,000 people was to sit down and expose their language, expose their job description of how they're violating their job and committing treason, and point out their rules, because under rules of evidence, under 402, it says the Constitution is admissible. The federal statutes are admissible. The rules are admissible. Supreme Court decisions are admissible. Same thing with 501, 802 under hearsay, 902 under hearsay. Go back and read these. Under Title 48, on leave of court, the only one who has to file for leave is the prosecution, not you and I. Under Rule 12, under Criminal Rules of Procedure, you and I are allowed pre-trial motions. Ladies and gentlemen, all this stuff, learn their rules. Use their rules against them. Point their errors out in their rules. Point their errors out in their language. Point their errors out in their job description. We brought up to you people about entry of appearance. All this stuff, ladies and gentlemen, is in there, in this paperwork. They would not seal a file if they were not scared of it. They only seal files when there is information in there that they don't want the public to know. You take this for what it's worth, ladies and gentlemen. Take it for what it's worth. I'm not twisting your arm. These people want to ridicule, let them. But they can't sit here and explain and justify, and they're going to try. Oh, well, the paperwork was no good, so they don't want the people. Now, the paperwork was that good. It exposed. And those of you that understood what I was doing understood that we was exposing, and it would make absolute sense to you why they sealed my paperwork. But I am home. I am on house arrest. I got to go back February 9th. But I am not done fighting. I am just sitting back, relaxing, getting new information, getting my head together around it. And we're going to go back in for round 5 of all this. So, ladies and gentlemen, know their language, understand it. Know their definitions. Understand their terms. Know their rules. Understand their rules. Know what their job is. What do you mean by that? It's like I pointed out, the prosecutor took an oath to the Constitution as a bar member. He could not mislead, misrepresent, misconstrue, put false information. That's perjury. The moment he stood here and he failed to uphold the Constitution and the federal statutes that violated the Federal Bar Association, that he disqualified himself by failing to uphold the Constitution. That violated the Smith Act, an act of treason and overthrowing our government, constitutional government. That violated Title 18, which is criminal charge, Chapter 115, 2385, which is insurrection and rebellion in form of treason. During a time of war, this is advocating the overthrow of our country. Ladies and gentlemen, like I said, know their job. Every one of them took an oath to the Constitution. Every bar member walked into that court had to swear that he understood the rules of the court, that he would uphold the Constitution and the statutes, and he had to pay a fee to enter into that court for 1 year. He violated his oath when he paid his fee, and he didn't do any of this. Ladies and gentlemen, this is all in this paperwork. Only thing I can sit down and tell you is, like I said, I will have Harvey come out and post this stuff and get this stuff back out to you new people on the big list, but go back into the archives and listen how to get on the big list. Go back on a Friday night, and Harvey will tell you how to get on the big list. But get on the big list. Get this information. Like I said, those who are on the private side cannot use this now. Those who are not on the private side can. Happy hunting. Thank you.
I use raw tackle.
Talk shoe.
Anyway.
Recorded live.
Hello, everybody.
Oh, Rod, welcome back.
Yeah.
Hallelujah.
Let me get done what I need to get done, and we'll get started here on this. Give me a minute.
Hey guys, this is Lamont. I'm listening to everything, and Jamie, where are you, man? We need a response from you, Jamie.
He's exercising his right to remain silent.
Tennessee is representing.
So Jamie, they need to know that if it worked for you, obviously you told me, you need to tell them.
It works like a pro. I've learned one thing in doing this is that you will never win. You will never win in trial court. Always the appeal that you win. Always.
And see, that's the problem. We should be able to walk in and show their errors, and in the trial court, they are supposed to be honest and have integrity, and this is where the problem lies.
Well, Rod, I believe I got a little information for you. I've been working on this with Lamont and Drew for the past 3-4 months, and when we went through the rules of the court, we found out that before they even put their hands on you, they must contact the Secretary of State, but I didn't know why that they should contact the Secretary of State. The reason is because it's a corporation, and before the corporation can bring any live being into it, we must question two things. Is the corporation's dues paid up? Is there a registered agent? What is his address? And the last thing, which is the most important thing in dealing with any corporation, how do you shut them down? Now, Drew went and got his W-9. It's listed as a unit of government. If they're receiving federal funding as a unit of government, me and you opt out. We're not. We are. If we're calling on credentials and for people who are public officials that we know that are not public officials, then all we have to do is contact the Secretary of State and report that entity. And before you get back, you're going to get escorted out the courtroom, out the building.
Okay, Jamie, this is Jeanette. In response to your, who is a registered agent?
Yes.
The registered agent is the Corporation Trust Company at 1209 Orange Street, Wilmington, Delaware. All corporations run through that.
Okay, let me tell you the problem. Now, what you said, you're exactly right. You're exactly right. But I want the registered agent of the court that called me before it. Because when I went to the United States District Court and asked them for the credentials of their officers, and I wrote and I got the address from the Secretary of State and the corporate control number, I wrote the registered agent, and the letter came back undeliverable. Under Tennessee Rules of Civil Procedure Section 4.02, you can effect a judgment on two things. If the corporation dues are not paid up, and if you send a letter to the registered agent and it's undeliverable or they refuse it, it's automatic. So if it's set up in Tennessee like that, I guarantee you it's set up in North Carolina all the way to D.C.
Well, let's get into, because again, if they're going to go back to the Secretary of State under the corporation, this falls back under foreign sovereign immunity. This falls back under Title 28, 602 to 611, is that they had to contact the proper registered agent in order to do this, and they've never done that. This is part of that court notice paperwork that we did back in 2008. But we got a bigger problem than that. You know, what you're saying is correct if we were running under the government or under the corporation, but that's not what we're running under. And this is what we're going to get into tonight, because we got a lot bigger problem of what we're dealing with, and it falls back under that Trading with the Enemy Act, where we are declared enemies of the state, and the fact that they are under the UN and they are a foreign national, and we have a completely different CF here. And we're going to get into some of this here tonight. So just sit back, cool your heels a little bit. We'll get into some of this. Let me take care of this so we can get rolling here. But you're right, Jamie, on what you're saying. If we had a legitimate setup, and that's the problem we do not have.
Rod, how's Sharon?
She's doing better. She's just upset with all this stuff. You know, she was forced into this against her will, and it's really not what she had in mind. But no, she's coming through it. She's starting to understand this new line of thinking that we're getting into here. But she just is not happy.
I know, but I'm fixing to mute out. But I want you to do two things for me.
What?
I want you to get back in your Bible, pretty hot in heaven, spend a lot of time with the Lord, because it's the Spirit of the Lord that you're going to need to fight this giant, okay?
Yeah.
All right. I want you to take Sharon out to dinner on me.
All right. Well, we've been out for my birthday, and we just got released off of house arrest and put out on due to North Carolina the way I was originally. There was a misunderstanding on the new probation officer's part of how I was supposed to be handled. But we got it taken care of within a couple of days. So just hang in there a minute. Let me get this stuff. Harvey, go ahead and do your thing, and we'll get started.
Okay. If there are new people on the call and you would like to be on the big list, the big list lets you know when there are calls. And we try and send it out with enough time for you to plan ahead, but sometimes it's a little late. We were a little late tonight. We apologize, but it is a holiday. Anyway, here's the email address. You send an email to rod-class-subscribe at rayservers.com. So that's ROD-class, CLASS, subscribe, SUBSCRIBE, at rayservers, all one word, RAYSERVERS.com. So it's rod-class-subscribe at rayservers.com. And you'll be on the big list. It'll hopefully announce calls. It'll be documents and files and things like that, and links and all that kind of stuff. So if you're new, we got about 2,000 or so people on the big list. So anyway, just use that address, rod-class-subscribe at rayservers.com, and you'll be all set. That's it for me, Ron.
All right, thank you. Jeanette, was that you I just unmuted in Oregon?
Yes, it most assuredly was.
Okay.
How are you, Rod?
Oh, no worse for the wear, but we've got a better understanding of what we're up against in this thing.
Yes.
And first off, I want to start out with thanking all the people that showed up at the court hearing. I want to thank Karen Hudis for showing up, and her and I was able to sit down for a 2.5-hour conference of being able to talk to a real person in what we're dealing with here, instead of all the noise and screaming and yelling and hollering in a quiet room. And the people that has helped Sharon, they have really worked with her and has really made her realize some other things here. But this court case has made her realize the amount of corruption that is involved. The retired FBI agent who was showing up on a regular basis, she got a very rude awakening to used to working the other side, and then all of a sudden seeing this side and going through the paperwork, could not believe the audacity of these people being this corrupt. And the word RICO was modified dealing with these people. And all the prayers that has been done. And ladies and gentlemen, I tell you what, the prayers, and it wasn't for the people coming in and watching. It was a big help and a spirit uplifting on my side of this thing, knowing what we were doing here. But what came out of this is the fact that with what we are teaching, ladies and gentlemen, it's not wrong. You have to know their wordage, their verbiage. You have to understand their definitions of what their words mean. Just don't look at the word individual and say, okay, an individual means me and all these other people out here. Go back and look up the congressional definition of that word individual. That is what's killing these people, is we're going back in and we're looking up their legal definitions of how these words are to be defined. They may put them out there. Our problem is we're looking at it and assuming it applies to us when legislation has given those words an entirely different meaning. And it doesn't matter whether you are working on the statutory side like we've been, the congressional side, or if you're going to work on the private side, and we're going to get into some of this stuff because there is some of this stuff you cannot mix at this time. There's a lot of things on the private side that you're doing with the equity side. From some of the stuff that we're reading, there is a distinct difference between the two. But we also got into law of agencies, which goes into contractual of master servant, and we're going back into principal and agent of who is principal and who is agent under these agencies. We're also going back into the UN, as these people are under the UN, under the International Organization Immunities Act. And this is some of the stuff that I want to get into here tonight, ladies and gentlemen. We've got a lot of hypocrites out here, and they are pointing fingers and making snide remarks, but the bottom line boils down to is we're dealing with a lot bigger problem. And with what we've laid out, and if Karen Hudis is on here, I'd like for her to hit her star 8. If she's not, I'd like to get her on here at another time as a guest.
Hey, Rod, excuse me. Dan223 is jamming up the board with all of his negativity. Just get rid of him, because it's jamming the board.
All right.
Dan223.
Got it. Ladies and gentlemen, this is where the problem lies. This is where the problem lies, with all the stuff that they're sitting here getting into. None of these people ever walked into a court. There is an integrity problem in these courts. It isn't the fact that the paperwork is wrong. You can walk in ahead of me, do the same paperwork, get your case dismissed. I could walk in and get my butt handed to me. There is no integrity in these courts. And this is one of the things that we went back and proved. This is one thing that Karen Hudis looked at after that 2.5-hour conversation. She went down and got into my files. And after she got partway into them, she just absolutely just slammed them shut and walked out. She did not realize the amount of corruption that we pointed out. And I've told you people from the very, very beginning of our conversation, of this show, I do not know how to defend myself. I do not know how to go in and make excuses for their corruption and their violation. I cannot walk in and justify and help them to railroad me. That's not my job. It's not my job to make excuses to justify their actions. My job is to walk in and point out procedural errors. This is what we did here through AIB Radio. This is what we were doing by going back into the congressional records of seeing the congressional intent of how the CFR and the USCs are to be defined. And it's like we have told you people, and you new listeners, we have gotten back into 1925 under Volume 43. It stops on March 4th, 1925. Under the congressional records, it sits here and states that House Bill 10,000, as of December 7th, 1925, Congress passed legislation to codify the statutes at large into the United States laws on December 7th, 1925. Problem of it is, when you get into Volume 44, which comes after Volume 43, which stops on March 4th, 1925, Volume 44 picks up on December 16th, 1925. Now, people, I want you to get a calendar. I want you to start on March 4th, and I want you to count all the months and the days up to December 16th, 1925, And I want you to sit down and see how it is possible that December 7th, 1925 was passed by Congress when it's not in the statutes at large. What we discovered under the Federal Register in the Industrial Recovery Act of 1935 is that Congress created an administrative commission and allowed the President of the United States to codify the statutes at large for administrative procedures into the United States Code. Now, that creates a problem. Because if the United States Code was administratively, through an administrative commission, and to the President of the United States was codified for administrative codes, then that can never apply to you and I. And this is what was pointed out in court. Among other things, of them working under the Foreign Sovereign Immunity side, of them working under the foreign state side, of Congress turning around and turning them under the UN side in 1945, thereby taking them out of our public offices that on Tuesday in November, for that 12 hours, they were put into a constitutional public office position. And after that 12 hours was up, they were taking over to the foreign side under the UN. Ladies and gentlemen, this is part of our problem that we're running into. We're not dealing with American nationals. And under that Trading with the Enemy Act, we walked you people through this, and an act respecting alien enemies of 1798, which created Title 50, Chapter 3, Section 23, giving the courts jurisdiction over alien enemy residents, and bringing in the Trading with the Enemy Act of 1917, where it requires for licenses and registration for businesses and anybody who dealt with Germany. In 1933, when they passed the bankruptcy under Section 2, you and I were declared by Congress to be enemies of the state under Title 50. And under the Social Security Act, we was given a registration number, 1935. 1940, the birth certificates come out, and we was listed as alien residents under the birth certificate. Ladies and gentlemen, they shanghaied us. All this was put into the court record, plus much, much more. On the 20th, I was pulled into court for a plea bargain. Prosecutor and the public defender sat right there and told me, said, Mr. Class, you may not agree with this. You know you're right. We cannot allow you to win. The only way you're going to get out is to plead guilty. Otherwise, you're looking at a lot of years, and it come up to 21 years. I looked over at the public defender. I said, is this where I got to sit here and confess my sins? Because we were sitting here talking about the Spanish Inquisition. And he looked at me and says, yes, you're going to have to confess your sins. You're going to have to plead guilty if you want out. And him and I had a talk in the back room. He says, Rod, you exposed too much. Your paperwork would overturn every court case in this country, not just D.C., in this country. And that is because we went in and we used the legislative legal definitions of what words meant, such as firearm. being a sawed-off shotgun, sawed-off rifle, fully automatic machine gun, a silencer. A person under Title 26, 7343 is a corporate employee. It runs right down. It has nothing to do with you and I. That's the same thing under Title 5, under 552, Freedom of Information. An individual is a citizen of the United States or a alien citizen applying for residency. That does not apply to you and I. All these definitions that we pulled in, that Congress laid out to how to define certain words. That's the same thing with corporations, associations, and partnerships. That goes back into the National Firearms Act of 1934 under definitions of corporations, associations, partnership. You look into this, it says persons as a corporation. It is a manufacturer that is licensed and registered. It is an importer. It is an exporter. It is a dealer. It is a collector. It is a pawnbroker, all being licensed, all being registered. That has nothing to do with you and I. Ladies and gentlemen, this is what we laid out. And those of you that's been with me, and if you've got my documents, you know I'm sitting here telling you the truth. They sealed these documents. The problem of it is, it wasn't this Judge Roberts. My paperwork went up to the United States Supreme Court. The United States Supreme Court ordered my files sealed because they did not want this stuff exposed. And we got this by first-hand knowledge. It was given to me by first-hand. It was told this stuff would expose and would overturn every court case. Those of you that want to be jerks on here, those of you that want to sit here and make your little comments, the bottom line, ladies and gentlemen, the paperwork that we turned out was devastating. As I said, I found out it went up to the United States Supreme Court and they ordered it sealed. They were not to pass this out to any law firm. Normally your paperwork gets passed out to law firms. Mine was strictly forbidden. We have the ability, if you people will follow in this, it's like prohibition. 80,000 people put a stop to prohibition. Look what we have done over the last 5 years to the banking system by coming in and challenging them and showing where they are securitizing. Look what is happening to the banking system over the last 5 years. It has destroyed the banking system because you people have opened this up by arguing it, debating it, filing it in your paperwork, and standing on your grounds. You people have sit here and done this over the last 5 years to the banking system. Ladies and gentlemen, exposing their trust, exposing their verbiage, knowing their rules, whether it would be on the private side. And like I said, once you're on the private side, you cannot come over to this side. You cannot come back to rules, statutes, and codes because the private side deals with a different a breach of contract. Under the international law, you need to get under the Universal Declaration of Human Rights. There's 30 articles because these people are under the UN, and the UN has been contacted by several different people on my case. And they have come back, and a comment has been made that if I would have put in a claim of equity into them, and the court refused it, they could have stepped in. What they looked at is the fact that I used their statutory law against them, and they are looking at it and watching it because they've never seen anybody use it as a means of pointing out errors and breaches on their side of the fence. Majority of people that use statutes and codes use it as a defense. Nobody, very few or rarely do they go back in and use it in a manner of which I did, of showing their errors and how it applies to them and what they did wrong to us. They're watching the case. I've got several people that they have called and talked to them, and it has come back to me that this is what is going on. Ladies and gentlemen, I can't get into much more teaching because we have pushed this thing as far as we can. We have showed that even running under the private side of this, what has happened here is the court has dismissed the DC charge and the Capitol Hill ground charge to turn around and re-indict me under a different heading of the Capitol Hill charge. When I was in court on the 21st, Judge Roberts proceeded to explain to me that I had a right to a public defender. If I could not afford one, one would be given to me. I had the right to file my own paperwork in. I had a right to a jury trial. Wait a minute, is this a new trial? I said, yep. I said, oh. And as soon as he said that, I realized the other charges were dropped. He started me, Brett, all over again with a brand new court trial. This stuff did work. They had to start me over again and give me another chance to come back in to try to shut this one down with not all of the paperwork that I put into the first one. After I realized what he was doing, I kept my mouth shut because I was supposed to get out on the 21st, and I was not going to do anything to screw that up. I would just keep my mouth shut, and I'll deal with it when I get out. But the point is, it was a brand new trial. It had the same case number, just left the zeros off the 253, and they changed the initial instead of RWR to RBR, therefore giving it a different number, different name, but being on the same case so they could securitize, because the first one, by doing what I did on the private side, paid it off, and they had to bring it back in because if we paid it off, they would have dismissed it. They could have used this, and they could have opened up every single court case. And ladies and gentlemen, those that have been with me the longest, you know, back in 2008, when we did that Corn Novus, that 4-page document, we got a college professor that called from California. I talked to for about 2 hours, telling me that that 4-page document would overturn every single court case because it dealt with foreign sovereign immunity. It showed that the government was foreign to us and we were foreign to it. The capital name, they had to prove that it was a corporation, but that 4-page document was enough to shut down the entire system. We got people out of jail. We got cases dismissed. We got children back. Ladies and gentlemen, my paperwork has got more dangerous since then. This is the whole point with what we're talking about. This is the whole point of what we're talking about here. These people are out of control. They're absolutely out of control. Did I fail? No. Did I lose? No. Was I forced into a conviction? Yes. Some people told me that with what we did, I could have bluffed them. Point of it is the standard is 3 times. You can't go over 3 with these people. When we start going into 4, the time started to get added up. There is a point from what we found out here later, but there's a point in court that you need to know the body language. You need to know the mood of the court. What I did was right. I found out later is that after I had Kessler, no other federal judge would touch me. Roberts, being the chief judge, had to take the case. There was not an option, there was not a choice. And because my paperwork went to the Supreme Court, he was told to shut me down any way he could. Not knowing that at the time, I went with gut instinct. I went with what I was pushing, and I was able to feel the resistance that I was going to get myself deeper into. So you have to learn to back off when the timing's right, regardless of what anybody else tells you. You're in that situation. You need to feel the situation and what's right for you at that time. You can always get back out with where I am, and you have another shot at this thing, but you can't do a whole lot when you're in that gray bar motel. The only advantage that I had, and it was also a disadvantage, is that the hearing aid batteries were dead for almost 2.5, 3 weeks. They would not replace my batteries. They were under the assumption if my batteries were dead, so was my brain, and so was my line of thinking, and so was my hands. Not knowing that I could write out 3 pages of documents and give to the inmates and teach them this stuff, even though I could not hear, I could talk to them, and I could explain it to them. And they went to the law library, and they started pulling up congressional definitions, and they started pulling up congressional records, and they came back and they absolutely crapped. All this that we're doing on the statutory side, all this that's being done by those who are on the private side, all those who are doing it on the UCC side, all those that are doing it on the law of agencies, because I got an email from a paralegal that this is what they're being taught. Ladies and gentlemen, these are all valid avenues to run. The one problem that we're running into is that we're not dealing with a government. We're not dealing with a corporation. We're dealing with international terrorism. This would be like Gary Powers. Those who know who he was the U-2 pilot that got shot down over Russia. This would be like Gary Powers trying to come in and run the statutes of the United States, or try to run the private side, or try to run the equity side in Russia. It's a foreign country, and he is an alien enemy in that country, trying to exert his rights. That's one of the biggest things that most of you people don't realize. And the fact that you people have not give that much thought of that is what is going on and how this country is being ran. It's under those conditions. And this gave me a lot of time while I was sitting in the Gray Bar Motel to give this some thought on that fact, and understanding and seeing all of the guards that was in there were foreigners. Very few Americans were in there as guards. Most of them were foreigners. Ladies and gentlemen, this is not a failure. The failure is the system. The system is the failure. We have to change the system. I want to read something here to you that I pulled up off of the UN Charter. Under the heading of Universal Declaration of Human Rights, it states in the preamble as one of the statements, whereas it is essential if man is not to be compelled to have recourse as a last resort to rebel against tyranny and oppression, that human rights shall be protected by the rule of law. That is in the preamble of the UN under the Universal Declaration of Human Rights. Now, what does that sit here and tell you? Whereas it is essential if man is not to be compelled to have recourse as a last resort to rebel against tyranny and oppression, that human rights should be protected by rule of law. Ladies and gentlemen, that's exactly what we have right here in the United States. The UN, under the preamble, gives us the absolute right to rebel against tyranny. And by going into court on the statutory side, as this is their procedures, as these are their penalties for violating, this is exactly what we pointed out to them. We pointed out under the rule of law. We pointed out under the Administrative Procedure Act. We pointed out under the Constitution, Acts of Congress, Statutes at Large, Code of Federal Regulations, United States Code, all the way down to equity, to where we exposed their trust and their finances. The integrity of our court system is our problem, not our paperwork. Those who hold public office is the problem. The issue comes down to this, and I want you to think about what I'm going to sit here and say, because we talked about this with McFadden in 1933. If your signature generates $1 million, just your signature, and if you were to hand in a birth certificate giving the same value of $1 million to pay off the debt, or if you was to walk in with gold bullion equivalent to $1 million, or silver equivalent to $1 million, or oil equivalent to $1 million, and the last ones that I've mentioned after your signature was to pay off the public debt discharge. Why would the system want to discharge the national debt when they can embezzle $1 million from your signature? This is what we're up against. This is the problem that we're having. It is the integrity and the corruption of our system that's supposed to be a lawful government that has been taken over by an international organization controlling this country under international setup. It isn't that hard to have figured this out. Sitting in jail has given me a lot of time to think. Just exactly what we're up against. We win because they allow us. Did my case get discharged with what we did? Yes, it did, but they brought another charge in. Does this private side work? Absolutely. Did my side work? Yes, it did, because we've had a lot of wins. We've had some failures. The problem of it is the fact that I exposed too much. I went from A to Z and laid out every single fraud, from the Constitution to the congressional acts, statutes at large, codes, United States Code, administrative, right down to the rule books. And we explained, and we caught them, in fact, that they didn't follow procedure because they didn't follow proper interference. Prosecution didn't file leave of court as he was required under Rule 48 under Criminal Rules Procedure. Under Criminal Rule 12, pretrial motions, I were to allow to file in. The problem of it is my paperwork was going into the post office, going straight to the judge's chamber, going straight over to the Supreme Court before it came down to the clerk of courts. Ladies and gentlemen, there's a lot here that has happened. A lot here that has happened. I want you people to keep the faith. I am. I want you to keep the fight going because 80,000 people put a stop to prohibition. 135,000 people put a stop to that congressman out of Illinois that made a comment about our troops. See, he said he would never apologize. And 135,000 people emailed him, made him apologize on C-SPAN. What we have done over the last 5 years has opened up the banking system for its fraud. And it's thanks to you people, not me, you people, that turned around and did this. But ladies and gentlemen, it takes the people to stand up. It takes the people to fight the system. A lot of the people that's bashing me are those who have Esquire after their name, or are working under that pretext, because this is the last thing they really want you to have for information, because it spoils their game. When you understand their language, and it doesn't matter, like I said, whether it's under the statutes, whether it is under equity, whether it is under UCC, if you understand their language and their verbiage, this is what Judge Tatanka in Oklahoma, back in 2006 when we was there, she made the statement, nobody's ever challenged the wording. Nobody's ever challenged the language. You challenge the language, you know their rules, and you know their job. Because if you know their job and you know their language and you know their rules, you can get them for breach. They breach their job description. And it doesn't matter what field you want to get into. Like I said, whether it's what we're doing here on the statutory, whether it's on the equity side, whether it's on the law of agencies, whether it's UCC, it doesn't make a bit of difference. If you know them three things and you understand them three things and you pull their definitions up, ladies and gentlemen, they're in trouble. they are in trouble. Because we're not supposed to look at this stuff. We're not supposed to understand their definitions. Whatever word they put up, the word person, okay, well, that means me. The word individual, oh, that means me. And that's how they expect us to run with it, and that's how they treat it, knowing that is not how it is applied. But I had a lot of prayers going up for me. I'm very thankful for that. I've had a lot of good people behind the scenes that was helping my wife. I'm very thankful for them. I've had other people that was going in and putting pressure on the system. I am thankful for them. I've had a lot of people working behind the scenes helping me while I was in there. Even though I was cut off for communication, biggest part of the time. But what little communication I was able to get in there, I was able to get certain messages to me of what was going on. But ladies and gentlemen, like I said, it is what you guys have learned here. You take it for whatever it's worth. If it has no value to you, then don't bother using it. If you can see the merit in it, ladies and gentlemen, this stuff was handed out to you freely because it is our freedom. It is something that we are sharing. This is not, I got a secret and I'm not going to share. Ladies and gentlemen, we're all in this boat. And the prisoners that I was in there with, majority of them were colored prisoners. There's only about 4 or 5 white guys in there. These guys were educated on a UCC. They were educated on the 1099s. And when I brought in what I brought in, it shocked them. Because they wasn't trained on the definitions, the rules, and the job descriptions of these people. The definitions is the biggest part of the things that we need to learn. Learn their language, learn their definitions, understand their terminology. And that is in any field that we're working in. But ladies and gentlemen, I have gone as far as I could run with this thing at this point. I can't run much farther because I taught you as much as I could on the Constitution. I taught you as much on the administration. I taught you as much on the congressional acts, the statutes, the codes, the rules, the regulations. I taught you what I pretty much know. I'm going to take some sabbaticals here. I will probably do private shows from time to time on here. My wife wants me to take some rest in what we're doing because, like I said, it has taken a toll on her, on what is involved. I need to get my head in around some new paperwork that we're working on. But I got people coming to me and helping me with, and working with me with, because of what we've done here has helped them. So they're coming to me and sharing information with me on what we're doing. Because right now, I'm probably one of the best prospects they've got to go run with this because of what we're involved in. But what really is the kicker is this, ladies and gentlemen, is the day that we was in court on the 20th, they had a Judge Scully make an announcement that the D.C. gun laws were unconstitutional and that the D.C. AG and the council were going to be found in contempt because they failed to uphold the Supreme Court decisions, while the prosecutor was forcing me into a plea bargain on that very issue. And when I asked, nobody knew anything about it. But it did come out that D.C. sometime around December 11th has to come back and explain why they should not be found in contempt. And the kicker is the prosecutor is part of the Attorney General's office for the District of Columbia. So the reality of it is the fact that he knew he was being found in contempt for violating the Second Amendment right, his plea bargain really went out the window. Because he could put a plea bargain in front of me when he was being charged for contempt of violation of constitutional protected rights. Think about that one. But ladies and gentlemen, like I said, there's a lot here. We've come a long ways from 2006 to almost 2015. A lot of education, a lot of knowledge is in the archives. Do I still need donations? Yes. Because the education that you're getting off these things, ladies and gentlemen, they're priceless. And donations should be voluntarily given because of what you're receiving off these calls. There's no price tag on this stuff. But you're not going to go anyplace else and get the knowledge that you're getting on AIB. And with what Harvey's doing on the big list of putting this stuff out, ladies and gentlemen, you have got a wealth of information. It isn't our paperwork, ladies and gentlemen. It isn't us. It's the system. We prove just how corrupt and how irresponsible they are and what they will do for greed on your birth certificate. It's going to take us to put a stop to it. If what I did scared these people, and this is what I have been told the entire time I was in prison, is I have these people terrified. They said, Rod, you have terrified these people. I ain't done anything. My paperwork terrified them. My knowledge has terrified them. Ladies and gentlemen, this ought to be a healthy hint. This ought to be a healthy hint because when I was first arrested back in May 30th, 2013, when they turned me loose, I was told then that these people were absolutely terrified and I haven't even started paperwork against them. I have done it against the state and I have beat them on administrative. I got them to admit they're not government agencies, they're not even employees or private contractors. And now that I have done paperwork, they have seen what I'm capable of doing on my paperwork. And all I've heard is how they are terrified. And ladies and gentlemen, if my paperwork was crap, like a lot of people on here want to sit down and make it out to be, that it's just crap, they would not be terrified of crap paperwork. They would not be terrified of somebody doing the type of paperwork that I put in. It would have no value whatsoever. And ladies and gentlemen, I'm telling you, these people are terrified of me. They are scared to death because of what we've done. They are scared that you people will catch on and you people will follow and start doing what I have, and that is the last thing they want done. By doing to me what they did, they tried to discourage you, and this is part of their psychological game. But the choice is yours, always has been. always been your choice. Nobody's ever twisted your arm. Nobody's ever forced you. I've given you people all the congressional records for you to read, draw your own conclusions. And for that, I want to thank you people for being listeners. I want to thank you people for being here, for supporting me, for what you've done, for the donations that I have gotten, have received. It has been very helpful. The donations Sharon got while I was sitting off to the side has helped her to get up to D.C. and back. And I thank you for that, because that's been very valuable to her and valuable to me, since it has helped her out a whole lot. But I tell you what, when I got an international lawyer coming in and looking at my paperwork and sitting here explaining that we have terrified these people,